hail to the victors valiant, hail to the conquering heroes, hail to Michigan. Isn't that right, Paul? Or are you still kind of listening to Sweet Home Alabama? I understand yesterday you were grateful that I didn't have much to say about Michigan's commanding performance in the Rose Bowl the other night and their defeat of what's that guy's name? Dick? Oh no, Nick Saban's Crimson Tide. I mean, Crimson Tide. That sounds like a detergent that they'd use in a slaughterhouse. We've got the Crimson Tide to wash away your blood. I mean, who comes up with a name like that? Shouldn't it be the sharecroppers? Shouldn't it be the slave masters? Or shouldn't it be this year the couldn't get it doneers? Paul, I'm sorry yesterday that I didn't have anything to say about the Rose Bowl, and I know you were grateful that I didn't. Take that gratitude and take it to Nick Saban and take it to the Crimson Tide and be sure to root Michigan against Washington next week. While we're on the topic of football, Mike and I Mike created, and Ball and Legitimacy, a fantasy football league, and we have yet to give praise to Bryce Mearness. Bryce was the champion this year. His team, I think, went 11-3 in the regular season, and then obviously he won out in the playoffs. Congratulations, Bryce. I appreciate the payoffs that you tried to make me to influence the outcome of the league, but I didn't really have any control over it. We think you won it on your own merits. And Bryce, thank you for not commenting on the fact that Mike and I met 3 times in fantasy football
I was
competition
waiting
last
for
year,
it. Come on,
and
go
my
ahead.
team
Lay it
went
on.
3 and
Go
0.
ahead, get it out.
Went
Get it out,
3 and
Norm.
0. In the last game, I forgot even to populate one of the players who'd been injured, and my 8 beat Mike's 9. But I didn't want to talk about it. I don't want to take anything away from Bryce's spectacular accomplishment. I'm trying to talk Mike into doing fantasy baseball this year, but I don't think we're going to be able to do it. It's a whole different level of commitment, a lot more time. And every time I play fantasy baseball, I crap out after about a month. It's the initial rush of the statistics that I enjoy, but the season is so long. There are 162 games. Keeping track of everybody and everything is all that I can do with the practice of law. I don't think it's going to happen. But congratulations, Bryce Mearness. What a world! So we've got Mike today. We're without the echo.
And everybody misses it too.
Echo. What's up with the echo thing, Mike? I mean, I thought we were going to approach
Look, the
2024 with a new bold attitude and aggressive mastery of technology, unwrapping
the
some new
problem
content
is
to
this
excite people about this thing. And we get on the air yesterday, and I can't even read your lips. You're sitting there like this was Mike yesterday on Law and Legitimacy. I can't
pissed. Pissed.
say anything. And so welcome back, Mike. Happy New Year. It's good to have you back.
Pissed. Yeah, happy New Year. I'm glad I can talk a little bit without hearing myself and trying to outrun the echo, echo, echo.
Echo. So what's this new newsletter we've got? And does this require more work?
So the website is up and functional. What I wanted to say yesterday is that it's still under construction, but the landing page is active. And what you can do is navigate to lawpoddaily.com right now. You'll scroll down, and if you're on mobile, you won't see this beautiful menu for you. You have to click to open the menu. But when you scroll down, you'll get this nice little pop up here on the right hand side. If you will, please give us your email. Drop it in there. Norm and I will begin doing weekly newsletters via email if you opt in, and it'll be a mix of what we're doing beyond just the day-to-day streaming content. So we discussed yesterday, Norm, you've got this idea of every man's con law, right? And putting together a course, about 84 lessons, something to that degree, correct?
Yeah, so we talked about doing this earlier in the year, or middle of last year, earlier in the year. Time is relative. We all know it flows, and then one day we flow out of it, and we're into eternity. And oh my God, where did life go? But I digress. The bad habit of all old men. But we started to talk about doing con law last year. Some people, including Lawyer Will, went out and bought the book, and then we dropped the project. And so we're going to work through all 84 assignments in the book in the course of 1 year, in 15 to 20-minute increments, and they will be posted. I've got to figure, I got to get cracking. And before I do, I want to make a recommendation to people of this book, Cass Sunstein's How to Interpret the Constitution. I listened to it over the Christmas break, and concluded I needed to read it because mere listening didn't do the book justice. And that's one of the reasons we're doing the newsletter as well. There are times where Mike and I are talking, and, candidly, we try to agree an hour or so before the show what we're going to talk about in the course of the day. But sometimes we have three topics and we get to one and then do two or three things we never talked about. And it's only after talking about them that you realize, wow, there was more to that than I realized. And so sometimes the written word is a good way to force you to organize your thoughts, to be more systematic, and to make commitments that are easy to finesse in an oral context. So when the Sunstein book, it it his point is that we have this thing called the Constitution. The United States Constitution is the supreme law of the land, and many people revere it, and for good reason. But how do we read it? How are we supposed to read it? How do we interpret it? It doesn't come with an instruction manual. At the very end of the book, in the Sunstein book, and on the audio, there is the United States Constitution. And as I was driving along the other day, it took 42 minutes to read the Constitution from beginning to end. And if you think about the outsized role of the Constitution in the governance of our daily lives,
Pretty
that's
small
no
amount of
time
time.
at all.
Yeah.
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 And, I was chuckling as I read it, because you'd hear a clause and think, wow, there's a whole cottage industry. And Sunstein's point is there's no right way to read the Constitution. Some are better and some are worse, and some are better or worse depending on the context. And so, what he does is a summary or an overview of the leading schools of constitutional interpretation in light of recent decisions that matter to many people: gay marriage, abortion, this, that, and the other thing. And then he says, if you decide the Constitution, you read the Constitution one way, you might come out with a different view. If you read it a different way, you might come out with another view. But people of goodwill can disagree about the right way to interpret the Constitution, but presumably we all have a goal in living in a better constitutional order. And so, what set of interpretive principles helps make a better constitutional order? It's a good book. It's a good introduction to the perils and the mystery of constitutional interpretation. So I recommend it highly. Again, How to Read the United States Constitution by Cass Sunstein. We'll talk at the beginning of the con law course about that. And it occurred to me in the middle of the night last night, because what else is there to think about in the middle of the night, that the Constitution is really silent about, frankly, the most interesting thing about it at all. And that is that we're governed by it. How did that happen? The preamble talks about we the people, establishing for the sake of domestic tranquility and so forth the Constitution, but we really didn't. Um, I mean, obviously there were Articles of Confederation, there were colonies, there was a revolt from the colonies. The Articles of Confederation weren't working. There was a constitutional convention, and those at the convention decided we needed a new constitutional order. They sent the document out for ratification for the states. It became effective when nine of the 13 colonies, or nine of the 13 states at this point, ratified the Constitution, and thus binding members of the other four states, whether they ratified or not. And it didn't take a majority of people in any given community to ratify at all. And so most people never really consent to be governed, even though that's the governing myth of the origins of public authority in the United States. Most of us merely acquiesce, and we go along to get along, and we make utility decisions about, how much fuss would it take to not obey the government? How much, and hence one of the reasons for prosecutions. How are we going to assure compliance with the law? We're going to deter people from disobeying it by prosecuting those who do disobey, and so forth. But the notion that what needs to be explained is the legitimacy of the constitutional order itself is silent in the Constitution. It's assumed to be legitimate among the various interpretive canons. Nobody ever really says, well, wait a minute, is the whole enterprise infirm because we the people really never have consented? And those who consented are long since dead? The so called dead hand problem, ye constitutional scholars will recognize. In other words, what does the dead hand, what does the hand of the long dead have to do with governing the lives of the living? And these are questions that Mike and I wrestle with here on Law and Legitimacy. We have an order to our lives. We have settled expectations. We have public institutions. We have methods of transferring power. And we have the rule of law, and we have courts that are open to resolve these disputes. But those disputes all take place within a larger set of background assumptions that say everything's okay. This is the order that we've agreed at some level to be governed by. But when I say agreed at some level, if you've taken an oath of office, okay, that's an express consent. Mike and I, as lawyers, have taken an oath to the Constitution. That's express consent. But the vast majority of individuals never read the Constitution. The vast majority of individuals don't know what's in it. We don't teach civics anymore. And they really have not consented to be governed in the manner in which they're governed. They acquiesce. They go along to get along. And my sense is that as the consensus about norms of public decency, of what a good life is, of the good itself, as those dissolve, the lack of consent to be governed in this way, and the lack of and mere acquiescence as a basis for cohesion is not enough. And at the margins, we begin to drift away from one another. And in the 2024 election year, that drift could have large and profound consequences.
Right,
So,
and Norm, I believe that acquiescence that you referred to is a subconscious acquiescence as well, right? In a society where we can admit that so few people do read and indulge the Constitution and ponder and late at night the way that you do about notions of a document that governs without saying it's governing, right? Uh, when that falls apart, is that what we're seeing transpire in modern times, right? When sort of that subconscious acquiescence to be governed falls away, and we're left with a resistance or a revolution of sorts, right? Fractured as it may be, and declining faith and deference to institutions, whether they're private or public.
well, and on that topic, I mean, we don't need to look any further than Claudine Gay at Harvard as an illustration of what you're talking about, Mike. I mean, Claudine has stepped down, from president of Harvard after shaming herself before Congress by basically being unable to talk about hate speech at Harvard and why it was tolerated in some instances and not others. And then questions began to arise about whether her scholarly corpus, which consists of 11 published articles, were in large part or to some substantial degree infected by plagiarism. And so she wrote a public letter to the Harvard community, realizing that her capacity to lead the institution was diminished and she had to leave. But then she wrote an op-ed piece explaining what was at stake, and that appeared elsewhere. Mike, tell us about that op-ed piece.
So the op-ed piece also appeared in the New York Times. It was just a day later, which I found interesting in and of itself, right? That the New York Times had debuted her resignation letter, printed her words, just the words, and no editorial, nothing else around it. Signed it sincerely, Claudine Gay. And the day after, what I've got on the screen is an opinion or a guest essay from Claudine Gay, and the title is "What Just Happened at Harvard is Bigger Than Me." And I believe you and I were exchanging texts this morning. I said that I'm disappointed with the way that Claudine Gay's termination or resignation has come to pass. I think that it is pedantic at best to uh, I guess acquiesce is the operative word, but for the millions of people who know deep down that she was not worthy of that position, that her being in that position represented the cancer that has enveloped our higher ed institutions and is representative of a larger institutional legitimation crisis that we talk about. And the technical reason, it's almost like sort of the famous mobster. I can't remember his name that went down for tax evasion.
Al
Uh,
Capone.
yeah, it's sort of like a tax evasion moment, right? With Al Capone, she goes down for allegations of plagiarism in large part, and of course, revisionists will try and buffer and augment the role of her congressional testimony in compelling that resignation. But by and large, I think that this was handled perfectly on both sides by Harvard and Gay when it comes to more of a crisis management scenario, right?
Mm.
Claudine Gay, so long as she was the president, the current president of Harvard, and affixed to that institution, was able to make her problems, PR or otherwise, Harvard's problems. And Harvard knew that. And so Harvard on the other side waited until that cancer had gotten so large to apply pressure and force the resignation. But Claudine Gay did indeed wait quite a while and did not make a move too early in resigning, such that it would be a spectacle that was permanently stained on Harvard, right?
Mm.
And so from that perspective, these allegations of plagiarism, we are talking about an institution of higher learning, and allegations of plagiarism seem to be, flippantly made because people don't actually care, because people don't actually read, Norm. The bigger issue to me is that because nobody cared about her scholarship, nobody knew anything to do with how little scholarship she had contributed into academia prior to when she was at Stanford, when she gained tenure at Stanford, or when she got to Harvard. Nobody knew anything about Claudine Gay until the moment where she was in the spotlight in front of Congress and absolutely took a nosedive. But this essay, Norm, that she writes is mind blowing in
Yes,
terms
she
of
says, among other things, this was merely a single skirmish in a broader war to unravel public faith in pillars of American society. Claudine, yes, it was. When you got in front of Congress and you couldn't distinct, you mumbled your response about anti-Semitism and Harvard's tolerance of it. That was a significant unraveling. And the real question is how you became president of Harvard in the first instance, and how it is that you're able to tolerate some forms of hatred when it serves your agenda, and not tolerate it when it doesn't. And is it the case, Claudine, that you became president of Harvard not because of the content of your scholarship, but because of the color of your skin and your gender? We had, it was obvious to many that she was selected as president because she was a black woman. And I guess any black woman will do, even a plagiarist will do. And you can't, Claudine, have the decency to say that truth matters. In this instance, because you didn't tell the truth about your scholarship and you couldn't tell the truth about your attitudes with respect to the Jewish community and anti Semitism, because truth was a stranger to you, you're no longer president of Harvard. But this is how she goes on to talk about it. Campaigns of this kind, the kind to insist that Claudine tell the truth, often start with attacks on education and expertise because these are the tools that best equip communities to see through propaganda. Wait a minute, Claudine. What's the propaganda? Maybe the propaganda was DEI and that diversity was an end in itself. And if we could just stick a semi qualified halfwit at president of Harvard, things would be better in educational institutions, and young women of color everywhere would have the idea that they could aspire to the top rungs of our society. You don't get to the top rungs of our society by looking a certain way. You get to the top rungs of our society and our institutions, at least in the good old days, by being a certain way. And that way was excellent, and that way was competing, and that way was recognizing norms that were rooted in a long tradition of excellence and character in Western civilization. Claudine goes on, but such campaigns don't end there. Trusted institutions of all types, from public health agencies to news organizations, will continue to fall victim to coordinated attempts to undermine their legitimacy and ruin their leaders' credibility. For the opportunists driving cynicism about our institutions, no single victory or toppled leader exhausts their zeal. You're not a victim, Claudine. You don't get a right to play the victim card here. You were exposed as a person of little integrity and exposed as a liar. We used to say in this country, liar, liar, pants on fire. Now, what are we supposed to do? Everybody gets a medal? There's a fascinating new book that my wife recommended for the holiday. I'm going to start it tonight. I'm giving it to everybody. I have it here in my office because I'm on my way to court after the broadcast today. I've got a couple murder cases that are going to be sentenced, and that means there'll be a lot of time sitting in the courtroom gallery waiting to be called. But it's called "Liar in a Crowded Theater: From Freedom of Speech in a World of Misinformation." Jeff Cossett. And there is, and we talked about this yesterday in the things to watch for in 2024. And Claudine Gay's resignation and her and her pouting thereafter gives you insight into the larger battle for truth and how it gets determined and who determines it. Claudine takes the position that she gets to broker the truth because she was at the helm of a leading educational institution. In a democratic society, truth is what persuades. Truth is what coheres in the marketplace of ideas. It doesn't depend on the seller or an imprimatur of the seller to be recognized as truth. And there will be a movement in 2024 to prohibit disinformation by guardians, by gatekeepers who don't like the fact that some truths are inconvenient to their narrative. And you don't have to look any further than the White House press spokesman. I mean, talk about Ellwanger and the Grift of the Magi. There she is. I can't even remember her name. Saint
Yeah, it
Pierre or
doesn't
something or other.
yeah, exactly. It doesn't matter. I'm reminded of this article from Adam Ellwanger, who those of you who were here for the week that Norm was West Coast wandering for the comedy boot camp recall that Adam joined us on the stream or joined me on the stream to discuss a different article. He followed this up just after Christmas called "The Grift of the Magi," and in reading Claudine Gay's opinion essay in the Times, I was reminded of this article that I think Norm I had sent to you in weeks prior or sometime prior that discussed these rhetorical devices and distinguished between what we regard as magic or what magicians do versus illusions or what illusionists do. And in particular, I'm fascinated with the prospect that in this case we're talking about what I would term as silent weapons for quiet wars, and I believe that's a book that I need to read, and it's also a Kill Army album from 1997 produced by Wu Tang. But in our day and age, it's increasingly a belief of mine that real war is being fought on different battlegrounds, and there are different lines on the map that have been drawn, and we are in this digital economy, and as such the weapons deployed by those with certain interests are guided by what is known to be the outcome of the use of intelligent use of language to coerce certain long-term ends. And with illusionists, Adam is very careful to describe, and I'll put it on the screen here. An illusionist induces a misperception by the audience, but implicitly acknowledges it as such. His illusion creates the appearance that the natural limitations of reality have been transcended. He tacitly concedes that things are not as they appear. The mystery posed by the illusionist is how he makes things seem different than they actually are. The mystery of the magician is how he can modify reality in ways that should not be possible. And so, relating back to the essay by Claudine Gay, I just want to revisit what you've already said here. As I depart, I must offer a few words of warning. The
Oh,
campaign
here we
against
go. Here we go. She's going to
right?
warn against the military-industrial
Exactly.
complex. Is
Well,
this
but this is what
Eisenhower? Is it
but this is what I mean.
Washington's farewell address? No, no, it's the whiner's remorse.
Right, but understand how much of an illusion she creates by crafting this one paragraph. As I depart, I must offer a few words of warning. The campaign against me was about more than one university and one leader. This was merely a single skirmish in a broader war to unravel public faith in pillars of American society. Campaigns of this kind often start with attacks on education and expertise because these are the tools that best equip communities to see through propaganda. But such campaigns don't end there. Trusted institutions of all types, from public health agencies to news organizations, will continue to fall victim to coordinated attempts to undermine their legitimacy and ruin their leaders' credibility. I mean, Norm, that is, pardon my French, fucking amazing, amazing gaslighting from somebody
That's
that
so true.
previously occupied the position of president of Harvard University, which she refers to as the corporation and is affectionately referred to in the press as the corporation. I'm I'm constantly I'm constantly blown away by the ability of the establishment and those who are pushed forward by establishment media to outdo themselves in gaslighting and casting the illusion of what the limitations of reality are as against what the truth naturally is, which is why someone like Vivek Norm is such a breath of fresh air and represents the opportunity of youth to change this paradigm in time and to course correct so that we can again re-legitimate American institutions because there is an objective notion of truth. And in this instance, it is absolutely not the case that these institutions will fall victim to coordinated attempts to have their legitimacy undermined. They themselves have undermined their legitimacy by systemically lying on every single categorical high level issue, whether it's related to health, whether it's related to economics, whether it's related to the law and the Constitution, our system of justice, whether it's related to BLM and police misconduct, whether it's related to the Second Amendment, whether it's related to the First Amendment, whether it's related to big tech and algorithms, whether it's related to foreign wars and geopolitical tensions. They have lied about everything, and that has totally unraveled. And here we have the former president of Harvard University saying that she is but a blip on the radar, just a skirmish in the broader war, because these are coordinated attempts to undermine legitimacy of our institutions. No, that should be categorically rejected.
Well, and hopefully it is. And she's gone, and Claudine, don't let the door hit you in the ass on the way out. And we'll be looking forward to your next scholarly production. In the first footnote, just let us know whether you've committed plagiarism in engaging in it. So Trump's before the U.S. Supreme Court. He's filed a petition for certiorari. That was for a foregone conclusion. And he's going to seek reversal and review of the Colorado Supreme Court ruling, keeping him off the ballot. I mean, the question presented in a cert petition is sort of it's not sort of you're supposed to catch the court's attention with that and say, look, here's the issue, we need you to decide it, and it's an important issue that reasonable minds can disagree about, or it's an important issue that needs resolution. Trump's petition is a serious petition. It will be granted by the court because there is confusion among courts throughout the United States about what to do with Section 3 of the 14th Amendment. But the question presented in the petition is kind of lame. I mean, did the Colorado Supreme Court err in ordering President Trump excluded from the 2024 presidential primary ballot? That's the conclusion. What's the issue, folks? And I think the issue is one that the court will address. And when certiorari is granted in this case, I predict the court will reframe the issue and direct the parties to brief what the court is interested in hearing. Again, a mere conclusory statement that the court erred is kind of meaningless. But I think what needs to be decided is how lower courts, or how other courts, or how administrative agencies are to address the question of whether a presidential candidate or a candidate for public office is disqualified by engaging in insurrection. Colorado had a hearing. It heard evidence over 5 days. It accepted into evidence the House January 6th committee report, which may have been a fatal error in this case. Now, that the document satisfied the public record exception to the hearsay rule, according to Colorado courts. But I pay close attention to what was in the House report and what was asserted versus what's been proven, and pay attention to Jack Smith's prosecution. There's a deep gap in the federal government's handling of the January 6th event. What am I talking about? Jack Smith never charged Donald Trump with engaging in a conspiracy to commit sedition. He never charged seditious conspiracy. That was the charge against the Proud Boys. That was the charge against the Oath Keepers. Seditious conspiracy is an agreement to use force against the authority of the United States government. The federal government has tried for 3 years to prove that Donald Trump has directed his minions in the form of the Proud Boys and others to engage in use of force against the government. They've never proven that case. The House J6 committee asserted what was never proven. And the United States government and the Justice Department didn't have the balls to bring that charge against President Trump because they know they can't prove it. And so, at the very center of this donut involving Section 3 of the 14th Amendment is a hole. And that hole can't be filled with speculation. That hole needs to be filled with evidence. And if we're going to permit state officials to say Trump engaged in insurrection when even the government in its prosecution of him doesn't bring that charge, there's a real problem. And it seems to me that the Supreme Court's effort has to be focused on how Section 3 of the 14th Amendment gets applied by local administrative agencies. And by that, I mean secretaries of state at the state level as opposed to on a national level.
Angry
And
Dog sent me a text earlier this week and asked this question, Norm. I'm going to just give it to you via audio rather than putting it on the screen. Uh, he asks, why isn't the arbitrary removal of President Trump from state ballots classified as voter suppression?
I don't know what's to be gained by that. It does. Well, is it voter suppression? I mean,
Well,
Trump saw.
here's what I believe, and for disclosure, Norm and I both have much homework to do on this petition, and we will. But my expectation with this petition is that it is going to discuss and attempt to articulate to the court that the urgent nature of this is not just the election is coming up, it's that efforts to disqualify, remove him from the ballot will be replicated, and that will result in millions and millions and millions of potential Trump voters being disenfranchised in real time.
Yeah, they won't be disenfranchised. They just won't have the ability to vote for Trump. They'll have to vote for someone else. So I'm not sure that it's voter suppression. I think the issue, we have Section 3 of the 14th Amendment, and it says what it says. It says that if a person having already sworn an oath to protect and defend the Constitution, then engages in insurrection or offers aid and comfort to those who do so, they cannot serve again. So that is the plain language, you know, summarized of the 14th Amendment. What effect does that language have on our public institutions now? And how do you get to decide whether a person who's previously sworn an oath to protect and defend the Constitution has engaged in insurrection? How do you do that? That's the more fundamental question in my mind. The practical impact of it, whether people get to vote for the candidate of their choice or not, I'm not sure I would call that voter suppression. I would say that's elimination of a candidate. And whether administrative agencies should be able to do that or not is an open question. But it seems to me that the Section 3 of the 14th Amendment is out there. It's the law of the land, just like Congress shall make no law regarding, establishment of religion.
Where'd you go, Norm?
Huh. I don't know where I went. I think Jack Smith hit the off switch. So the question of constitutional interpretation raised by Cass Sunstein is front and center in this issue. What are we to make of that language? Or more to the point, how is it to be implemented? And I point out the weaknesses in Jack Smith's prosecutorial theories and the Colorado Supreme Court's decision to justify use of the House J6 committee as the place where my analysis of this would begin if I were on the United States Supreme Court. A branch of government took the position that Donald Trump had engaged in insurrection, and they impeached him for it, and they failed in the impeachment. A criminal prosecutor then decided to charge Trump, and he didn't charge him with seditious prosecution. Therefore, the premise on which the 14.3 exclusion of Trump from the ballot is based, there's no foundation in fact for it. You've got a congressional report that reached a conclusion without evidence sufficient to persuade members of the Senate to vote to impeach, and you've got a prosecutor rather in the form of Jack Smith with a federal grand jury and all that entails, who investigates this case thoroughly and doesn't have the goods to bring the case he wants against Donald Trump. So my view is that there's been no judicial finding, there's been no governmental finding after a full and fair hearing that Trump engaged in insurrection, and he should
But
not
that
therefore be
and
kept off the
here's gonna
ballot.
be the best use of this word that you've ever heard from me, but that fact finding has been arbitraged by the lower court in Colorado and then reviewed on the record by the Colorado Supreme Court. And now that is before SCOTUS. So when we discuss voter suppression, I think and you talked about the central thesis of this case or the question that should be presented, because I agree. Section 3 of the 14th Amendment notwithstanding, I take issue with the fact that the lower court in Colorado even dealt substantively on the merits of trying to parse whether an insurrection occurred. That
But that article, who was I can't remember the names of the authors of the article that came out mid-year last. It will be published this year, I think, in the University of Pennsylvania Law Review. It basically said, hey, every person who registers candidates, every Secretary of State has a constitutional obligation to make this decision. Those authors asserted that, and so some people have taken them seriously. We saw it in Maine and in Colorado as well. And so now I think the Supreme Court has to address the methodological question. And so to me, the question presented should be the following. First, you have to assume that Section 3 of the 14th Amendment is the law of the land, because it is. And so the question presented should be, what methods should be used to determine whether a candidate engaged in insurrection, a candidate for president engaged in insurrection, sufficient to evoke imposition of Section 3 of the 14th Amendment. And I think that will be the central issue. I predict that the Supreme Court will avoid excluding a conclusion that results in Trump being
well,
excluded
here,
from
so
the
so
ballot.
now that you're making predictions, I wanna get, I'm gonna put this back on the screen here, betting odds on Trump's Supreme Court case. So, we've got 3-to-1 odds on reversal on due process grounds, so that's the best odds if you're betting. 5-to-1 odds that they affirm, which is, a little scary to think that they would affirm, with those sort of odds. 8-to-1 that they rule that there was no insurrection, which that's, I mean,
That-
pretty
yeah.
promising in terms of 8-to-1 odds. I'm not sure who's making the books here. 10-to-1 odds on reversal with no majority decision. And I don't even necessarily want to get into that because that's kind of terrifying. 20-to-1 odds a 4-to-4 decision. Yeah,
That's a polite way of saying BS.
right, because Clarence Thomas recuses himself. I think that those odds are way too generous. That's not going to happen. 25-to-1 throwing out the case because Section 3 is not self-executing. And it's amazing that these odds are getting worse the more intelligent the conclusions become. 25-to-1 they grant, but they don't expedite. So they're going to grant certiorari, but then they would push the decision out. To me, when I'm reading the rest of these, I'll go ahead and read the rest of them. 25-to-1 holding that the presidency is not covered by Section 3, 25-to-1 an exclusive federal question, 50-to-1 Trump didn't engage, 99-to-1 the president is not an officer, 99-to-1 the court would not grant cert. So of all of these, to me, the one that seems the most likely, and I can't really articulate why right now, but the 25-to-1 for granting certiorari, but then not expediting the case such that they wouldn't rule on it till sometime next year. That to me seems the most likely for the court to avoid the politicization of the moment,
Here's the
right?
problem with that. While that would affect Colorado, that would leave Trump off the ballot in Maine.
But
Like the
Colorado itself, Colorado Supreme Court stayed its own ruling pending the
Maine
outcome of
has,
that. So they opened the door for that.
but Maine right now he's off the ballot
Well, then
because
that
of the
doesn't preclude another case from being brought,
yeah.
you
No,
know?
I agree that the political decision would be to punt on this. I think you're probably right. Grant but not expedite, and then resolve the case after the 2024 elections. Um, Having said that, my second choice would be to go back to the top, the 3-to-1 case. I agree that is the most likely problem. The most likely result, reversal on due process grounds, and then throw it back for further argument and consideration. However, the safer political course would be to defer a decision, to grant a stay in each case of any state order that precludes him from being on the ballot, permitting him to be on the ballot this year, hope that he loses and it becomes moot in 2025. And then, to the degree that this is a problem that's likely to recur, have fuller argument in a less highly charged environment. That's pretty shrewd, Mike. I think you're right on that, and I can see John Roberts wanting to do that for all sorts of reasons. That places the impetus rather, or on Trump to have to seek stays in cases where he is kept off the ballot. But that probably is how it's going to break out. So. Well, folks, we've talked our way through another, 40 minutes and 15 seconds of your life. Thank you for sharing it with us. We hope you've gotten something here. We certainly did. It's always great to take your comments and to talk about this amazing world that we inhabit and try to make sense of it. So welcome back. It's 2024. We're in for a bumpy ride. And the good news is it'll be over in 363 days. But boy, there's going to be a lot going on between now and then. And
361, right? We're 4 days in.
Yeah, that's true. You're right. I can't. If I could do math, I'd be in medical school, right? So, Mike, how do people find us?
You can go to lawpoddaily.com. That would be the first place that I would go if I were not me, but I liked listening to all of this. Lawpoddaily.com. Sign up for the newsletter. You can also find us on Rumble, on YouTube, and on X at LawPodDaily. Law and Legitimacy. You can find us on Apple Podcasts, Spotify, Google Play, Overcast, wherever you find premium podcasts. As we say here at the bottom of the website, listen to us on Google Play, on Apple Podcasts, wherever, and leave us 5 stars. And as I've always said, and now Norm has adopted, leave us a nice comment as well. But if not, just leave us alone. Norm.
Paul, remember, as you're driving along today, going about your day-to-day tasks, mourning the Crimson Tide's evaporation in the Rose Bowl, that there is hope. Hail to the victors valiant. Just hum that. Bum 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 bum. Have a good day, everyone. See you tomorrow.
I can hear him already. Roll Tide. All right. See you tomorrow, everybody. Thank you for being here. Jackson, thank you for the mic tip on Norm. Norm, we'll make sure you're tuned up as much as possible because people really want to hear you talk.
Oh, I bet they do.
See y'all.